When we talk about the United Nations Convention on the Use of Electronic Communication, it is an international contract, an international treaty aimed at facilitating electronic commerce by establishing uniform rules for the use of electronic communications. It provides legal certainty and predictable for business engagements in cross-border transactions by ensuring that electronic communications are as legally valid and enforceable as traditional paper-based communications. Parties to the convention include member states of the United Nations who have ratified or acceded to this treaty. These countries agree to abide by provisions of the convention and implement its principles into their national legal frameworks. The convention works by establishing rules regarding the use of electronic communications in various aspects of contract formation, such as the formation and validity of contracts, the determination of parties' intentions, the time and place of dispatch and receipt of electronic communications, and the use of electronic signatures. It also addresses issues related to the admissibility and evidential weight of electronic communications in legal proceedings.
The convention entered into force November 23, 2005 and entered into force on March 5th, 2013, signed in the city of New York. The convention applies to all electronic communication exchanged between parties whose place of business are in different states and were at least on the dues express choice of the parties. Contracts concluded for personal, family or household purpose such as those relating for family law on the law governing succession, as well as certain financial transactions and documents of title are excluded from the scope of application of the convention.
This convention operates in a wide range of cases involving international contracts and the use of electronic means for their formation and execution. Some of the cases in which this convention may apply include international commercial contracts, sale of goods contracts, online services, electronic signatures, data messages, and security and confidentiality. The United Nations Convention on the Use of Electronic Communications in International Contracts is relevant in any situation where parties involved in an international contract decide to use electronic means to conduct their commercial transactions, providing a legal framework to ensure the validity and the security of such transactions on an international scale.
Legal problems arising from the agreement will be described. Although the main objective of the agreement is to solve and facilitate the application of electronic communications, some provisions could generate doubts about the legal certainty of the agreement. The first problems arise from the location of the contracted parties. The possibility of being able to contract by electronic means at the international level is practical and effective. But the question here is, how do you enter the place of the contracting parties? It is important to know in what state each party is located, because aspects such as jurisdictional and the law applicable of the contract must be determined. As it is electronic and international in nature, it can be more complex to determine the location of the person of the establishment. Another problem is the binding nature of the offers. How this works? Another question is to solve is, do electronic establishments that offer goods or service through such system automatically be binding of the person who see the offer?
To solve the question raised above my partner, it's necessary to review Article 6 of the agreement, where the place where the contractual parties are to be located is established. The article starts talking about the presumption of establishment. We can understand that if any of the parties has establishment in the place indicated by it, unless another provides that the party making such indicated doesn't have establishment in such place. Establishment without indication. If a party has not indicated a place of business and has more than one place of business, its place of business for the purpose of this convention is the one which is most closely connected with the relevant contract. This determination takes into account the circumstance known to or foreseeable by the parties at any time before or at the time of the conclusion of the contract. Individuals without a place of business. If a natural person has no place of business, his or her habitual residence will be taken into account. The other question to be answered is, do electronic establishments offering goods or service through a such system automatically have a binding character with the person viewing their offer? And to understand this question, it's necessary to know that electronic establishments that offer goods or service through information system do not automatically present a binding character with the person who sees their offer. The binding nature of an offer depends on a number of factors and is not automatically established by the mere fact that someone views the offer online. However, if the party making the offer clearly express its intentions to be bound by its offer, then it may be binding.